Peace and love, everybody. This is Zen coming back at you again. Now, you thought it was over just because I provided a lecture today, November 17, 2020, earlier, does not mean I was not going to present a flowchart. Now, prior to watching this flowchart, it is mandatory that you watch the previous video. If not, it's going to be somewhat of a confusion because a lot of the lecturing part was done in the first video, and this is a flowchart to get you straight to the point, straight to the information as is, okay? So I highly recommend this. I highly recommend that you watch the previous video. Also, another thing too is this information can be found in any of the states. It's synonymous. Just because this is pertaining to the public law, public statutes at large, doesn't mean that the states have adopted this. Of course, they have adopted this information as well. So you may want to go ahead and look into that too, okay? So again, you guys, watch the first video, then watch this video. I will not explain a whole lot of information pertaining to this video. It's a flow chart to get you straight into it, okay? Without further ado, let's do it. Public Law 93-595 enact to establish rules of evidence for certain courts and proceedings. Evidence and judicial notice beginning of the end game continued. Let's focus on the red side. Please feel free to donate. Cash App is right there. Email address is right there. Let's go. Okay, so I'm going to read this part for you. These rules apply to actions, cases, and proceedings brought after the rules take effect. These rules also apply to further procedure in actions, cases, and proceedings then pending, except to the extent that application of the rules would not be feasible or would work injustice, in which event former evidentiary principles apply. Take that into consideration. Okay, let's go here. Article 4, relevancy and its limits. Article 5, privileges, and Article 8, hearsay. I wonder why I put that on the right-hand side of this video here, huh? Okay, let's see what's going on down here. Preliminary questions, questions of admissibility, generally, relevancy, condition of fact, presumptions, relevant evidence, methods of proving character, witnesses, opinions, and expert testimony, hearsay. This sounds like what? Bar members. Okay, sounds like what? Bar members. I explained a little bit about this in the first video, but I highly recommend that you read the Public Law 93-595 in its entirety so you can go ahead and get the gist of the information. Okay, moving forward. Now, over here we have what? Article 2, judicial notice. Article 9, authentication and identification. And we have here, examples of it will be U.S. Library of Congress records, journals, etc., treaties, public statutes at large, articles of confederation, United States Constitution, and state constitution, etc. Use your imagination. You know how to do this. Now, warning, stay away from this side. It's solely reserved for bar members. Of course, I provided proof in the evidence. I mean, the words that I'm utilizing pertaining to that right side, which is in black letters or whatnot. We know that they do it every time, all the time. They will never do a judicial notice. They will not do that. I wonder why. We already know why. For those who don't know, you may want to go ahead and pay close attention. All right, so listen here, attention, remain on this side for the ultimate protection. Moving forward, let's focus on the red side, you guys. So here, this is in regards to Rule 201, judicial notice of adjudicated facts. So we have kind of facts plus when mandatory, which the information can be found where Rule 201B, kinds of facts, and Rule 201D, when mandatory, equals what? A court shall take judicial notice if requested by a party and supplied with the necessary information. A judicially noticed fact must be one not subject to reasonable dispute in that it is either, number one, generally known within the territory of the trial court, or two, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So that information you present when you're conducting your judicial notice, what? The accuracy cannot reasonably be questioned. It cannot be questioned. The accuracy regarding the source of the information cannot reasonably be questioned. Think about what I've just said. It's undebatable. Okay, let's bring it down a notch here. Let's go ahead and make it a little simple, just to be on the safe side, so we won't have any miscommunication or confusion. Again, Rule 201B, kinds of facts, plus Rule 201D, when mandatory, which is found in Article 2, judicial notice, and Article 2, judicial notice again regarding public law 93-595 An act to establish rules of evidence for certain courts and proceedings equals what? The party has requested judicial notice and supplied the necessary information to the court. Consequently, said judicially noticed fact is undebatable, generally known within the territory of the trial court, and are backed by sources whose accuracy cannot be reasonably questioned. It cannot be questioned whatsoever. Boom. Okay? Short, concise, straight to the point. Let's move forward. This is a very short but effective flowchart. Let's go. So, okay, let's take a look at regarding Rule 201, judicial notice of adjudicated facts here. Look at here. Number one, you need to know this. Time of taking notice. Judicial notice may be taken at any stage of the proceeding, okay? It can be taken at any stage of the proceeding. Moving forward, judicially noticed facts. Let's take a look at that. So we have, what do we have here? Article 9, authentication and identification. Now we go down to Rule 901, requirement of authentication or identification. And we have here, letter B, illustrations by way of illustration only and not by way of limitation. The following are examples of authentication or identification conforming with the requirements of this rule. So boom, number 7, we have public records or reports. Number 8, ancient documents or data compilation, process or system. Okay, methods provided by state or statute. So what you guys need to do is you need to go back to the first video to go ahead and get the information pertaining to what we just mentioned here. So go back to the first video to get that information, okay? All right, here we go. So let's look at this again. So we have what? Public records or reports, ancient documents or data compilation, process or system, methods provided by statute or rule. Examples will be U.S. Library of Congress records, journals, etc., treaties, public statutes at larges, articles of confederation, United States Constitution, state constitution, decisions made on Supreme Court cases, etc. Use your imagination, you guys. It ultimately depends on your situation and your creativity regarding said matter. This will be discussed at a later time. Think about everything that is just said here, okay? Moving forward. Let's keep in mind, Rule 101. What is the scope of Rule 101 regarding the public statutes at large? Is this. These rules govern proceedings in the courts of the United States and before United States magistrates to the extent and with the exception stated in Rule 1101. That exception, you can find it where? On the first video. I explained that in the first video. I actually read that. So go back to the first video. Okay, let's move forward. Okay, so Rule 102, purpose and construction. These rules shall be construed to secure fairness in administration, elimination of unjustifiable expense and delay, okay, and promotion of growth, excuse the error, and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. Boom! I didn't say it, it said here. Okay, Rule 103, rulings on evidence. D, plain error. Nothing in this rule precludes taking notice of plain errors affecting substantial rights, although they were not brought to the attention of the court. Preclude, you guys need to look that up. Preclude means to prevent taking notice of plain errors. Prevent. So they can't. Nothing in this rule shall prevent taking notice of plain errors affecting substantial rights. You need to look up substantial rights. And trust me, you will see where I am going with this. And remember, judicial notice can be what? It can be done at any time of the proceeding, okay? Think about what I just said. All right, you guys, so I went over everything, basically everything in black on the right-hand side. That's basically for bar members. They do it very, very well. We already know this. And everything on the right-hand side, we know belongs to us, or we can do this accordingly. No, we're not trying to say we're subjected or whatever the case may be, but a lot of people are already in the situation that they are, but they don't know how to get out of it because they're not being told how to get out of it. And unfortunately, that information is not supposed to be hidden that way. Yes, you will never catch an attorney, bar member, whoever it is, go ahead and automatically do a judicial notice. They will not do it. And if they do it, it's in the interest of the court. It's not in the interest of the client. We already know that, okay? I have never seen a successful judicial notice done by an attorney against the court. Hello. And you know what I'm talking about too. A lot of people who's being held in contempt talk about the Constitution. Why talk about it when you can have jot down on paper in regards to a judicial notice? You want certain things to be done, judicial notice. Like I said, you can go to your respective states in those areas and you'll find this information within those statutes. Trust me, and it is effective and there's nothing they can do about it. All right, so thinking between the lines, become creative, man. You guys can do this. High energy, good vibes. Again, stay away from this side. It's reserved solely for bar members. They're always arguing, they're doing presumptions, they're doing hearsays and whatnot. Stay away from that side. Focus on straight facts, okay? On this side, okay? Article 2, judicial notice, etc., etc. Come on. Okay, you guys, man, just wanted to go ahead and share that with you. Again, I highly recommend that you go watch the first video that was put out November 17, 2020. I know you're tired of me saying that, I'm sorry, but I gotta say it because a lot of people just like to shoot to the straight stuff or shoot to the short videos, not knowing that they're missing a lot from the first one. Yes, it is, again, 33 minutes long, but it is worth it. Worth it. It will prepare you for this flowchart, and you will be like, oh, man, this is cool. Very informational. All right, you guys, again, so hopefully this was beneficial to you as it was for me. And again, Public Law 93-595 enacts to establish rules of evidence for certain courts and proceedings. Evidence and judicial notice beginning of the end game continue. Let's focus on the red side. Again, please feel free to donate. Cash App is down there, and email me any questions or concerns, comments. Thank you so much. You guys have a great day. Zen out.